Welcome to Trial Lawyer View, a podcast for and about trial lawyers. We tell the stories about trial lawyers who go to battle every day in courtrooms throughout the United States for injury victims. This is about their stories and their practices. Trial Lawyer View is brought to you by Synergy Settlement Services. Synergy allows trial lawyers to focus on what they do best by handling the difficult issues that arise in settlement, like troublesome lien resolution issues, Medicare secondary payer compliance, government benefit preservation techniques, and complex settlement consulting. Without further delay, here is another episode of Trial Lawyer View with Bryan Smith.
Welcome to Trial Lawyer Review, the podcast that brings you inside the world of litigation and the fascinating stories behind some of the most significant trial lawyers in the country. Today, my guest is Bryan Smith, a seasoned trial lawyer dedicated to seeking justice for victims of sexual abuse, medical malpractice, serious injuries, and wrongful death. With over 100 million in settlements and verdicts, Bryan's commitment to his clients shines through in every case he handles. Drawing upon his background as an advocate for children suffering from mental illness, Bryan brings a unique perspective and unwavering dedication to his practice. His expertise extends beyond personal injury law. He's also a graduate of the Strauss Institute for Dispute Resolution Mediation Training Program and actively mediates cases. Bryan's exceptional skills as a professional actor further enhance his courtroom performances, setting him apart in the legal field. Today, we're going to explore Bryan's approach to complex litigation, his strategies for securing significant recoveries in car crash cases, and the profound impact of his work on the lives of his clients. He's a compassionate trial lawyer who's making a difference in the civil justice system and beyond. So, Bryan, welcome to Trial Lawyer Review. Thrilled to have you join me as a guest today, and really appreciate you taking the time to be with me.
Thanks for having me, Jason, and thanks for the kind intro. Appreciate it.
So you've had a pretty diverse legal career advocating for children suffering from mental illness, as I said in the intro, before becoming an attorney. How has your background shaped your approach to representing victims of sexual abuse, medical malpractice, and wrongful death in the civil justice system?
Yeah, that's a great question. I think working in the mental health field before I went to law school helped me with empathy and helped me understand the plight of the underdog, so to speak. Folks that are up against difficult odds, up against government agencies, perhaps, that are not providing resources needed to be able to get treatment, get medication. And specifically, I worked in a psychiatric hospital for children where I saw firsthand the effects of trauma on children. So whether it's sexual trauma, physical abuse, physical neglect, you see how profoundly children are harmed due to their childhood experiences. And I think that, I had no idea at the time that it would inform my perspective on the practice of law. I didn't even know I was going to go to law school when I was working in the psychiatric field. But in hindsight, I see a deep connection between that experience and understanding their plight and their struggle back in the day when I was in the hospital supervising a team of mental health providers to what I do today, which is helping folks file lawsuits against the church or the Boy Scouts or government entities that allowed them to be abused when they were children in the context of foster care or perhaps by a priest or in a school setting, that type of thing. And the damage that is inflicted upon the child, really what I learned is it doesn't become fully realized or understood until they are adults, until they start navigating intimacy issues and relationships, and then they start looking at, addiction issues. Why am I addicted to drugs and alcohol? And you start to connect those dots. and it all starts to make sense. And I think if you can understand trauma in that context, you can really become a more effective advocate for your clients. And so, I'm obviously talking about sexual abuse cases here, since that's about half my practice. But I also think it helps in the context of any case where you're trying to understand trauma and understand, how a particular traumatic event has affected someone. So if you can become articulate in that vernacular, that terminology of trauma and psychological and emotional distress, you can really make the client feel understood and heard. And I think that, and this is just a long answer, and I apologize for being so long-winded about it, but it's an important topic, because if the client feels understood and heard, they feel empowered and they feel aligned with their counsel. And together, if they are feeling that way, they're going to be a lot more confident going into litigation. And they're going to be more confident that you're going to be able to convey that story to the jury. And then the trial lawyer is going to be like, okay, we're all on the same page here. Let's go try this case. And that's what gets the best result for the client, is that confidence that the truth will prevail, that we are going to be able to tell this story in a way that really impacts the jurors on an emotional level.
It's interesting to hear you talk about that. And actually, I've talked about this with a lot of guests, that idea of being able to connect with your clients, what they've gone through and the impact, and how to adequately convey that to the jury. But your take on it is just an interesting one. Particularly, my background is also, I got an undergraduate degree in psychology, never worked in that field other than when I was in college. I did an internship in the psychiatric wing of our jail system here in Orlando, which was eye-opening to see the kind of things that people that were working in the system here, trying to move people out of the legal system into treatment for what they were suffering from, which was the reason they were jailed, not because they're necessarily criminals, because of deep psychiatric issues. But anyway, that the idea of being able to connect with what someone's gone through is, to me, seems what sets certain lawyers apart from other lawyers, because if you can really convey that to the jury, that's a difference maker in the outcome, but also, as you said, the importance of the person who's been injured feeling like you're on the same team too, that you really get to some extent what they've been through. I think that is a little tough, having been involved in a pretty significant personal injury case myself. I do think unless you've really been through something, it's hard to understand every aspect of that. But the idea that you've conveyed it, I think, is an incredibly important one.
Yeah, and speaking about inmates and understanding the root cause of why they're there, I mean, this obviously applies to the context of criminal defense too. So that's why the Jerry Spence Trial Lawyers College has this, the groups of folks that show up to those seminars and those 3-week courses are from the criminal defense world and also the personal injury world. And you wouldn't think that intuitively there are overlaps there, but there's a lot of overlap between criminal defense and personal injury, because what you're trying to do is understand your client's story. And a criminal defense lawyer is going to be much more effective if they know, if they are able to understand why somebody did something. What was their motivation? Was there some other cause other than they're just a bad person, which is the narrative of the prosecution? And one example of that that I will never forget is when I was working in a law clinic in law school, and I was assigned a real case. And my professor had me sit down with a classmate of mine and interview someone who had been charged with assault. They had allegedly assaulted their mother. And I sat down with this client, first time interviewing a client, first time taking on a real case. And the first thing he said to me was, I choked my mom. This isn't a case. What are we doing here? So, I'm guilty. I did it. I choked my mom. And I looked at my friend and I was like, well, this is pretty easy. We just need to get a plea deal here. He's confessing to us. I think the police report said he confessed to the police when they showed up. I choked my mom. And this was all videotaped because it was part of a clinic. And my professor watched the video and critiqued us both, my classmate and I, for not asking more questions and trying to find out the true story here. What happened? And so we brought him back for another interview, and the story was much more nuanced and compelling than the first version that he gave us. And the story, and I'll just tell you the nutshell version here, was that he lived with his mother. His mother had a severe alcohol problem and drug problem. And she had parties. This is in downtown Tacoma, in a bad part of town. And she would have party after party after party. And there was just strangers pouring in and out of the house all night. And he was in high school. He's a big guy, probably 250, 275 pounds. And he has a little brother who's like 10 years old. And they would play video games together just to get through these evenings, which were crazy. All kinds of drug use and alcohol. And my client was straight edge, never touched alcohol, never did any drugs. And I think he was 18 or something. So he was either a senior in high school or just graduated. But anyway, the night before there was a party, and someone had thrown a chair through their sliding glass door. And the client of mine had to stand guard throughout the entire night, fending off people who were trying to walk in through this open glass door and steal things out of their house. So he's worried about the safety of his little brother. He's worried about the safety of his mom and himself. And despite the fact that this had happened the night before, mom has another party and gets out of control. And he comes downstairs because she's starting to throw things around again and is breaking things. And he grabs her by the shoulders, and she's, weighs 100 pounds soaking wet probably. He's 275. Grabs her by the shoulders, pushes her up against the wall in the kitchen and says, Mom, stop. You've got to stop this. And she says, you're choking me. You're choking me. And he, after a while, because she's screaming this over and over and over again, he breaks down crying, runs upstairs, says, I choked my mom. I choked my mom. And cops show up because there's all this chaos. Lights are on. He runs down to the police and says, I choked my mom. Take me away. So they put him in handcuffs, arrest him, charge him with assault. They look at her. There's no bruising on her neck. There's no indication of injury of any kind. And so that's the story. And so it was a really important lesson in empathy, to understand where someone's coming from, because you really don't know. The confession is probably, the most surface level understanding of a fact pattern in a criminal defense case. And you really can't understand the case unless you dig deeper. And so I took that lesson in the criminal defense context, and then through Spence College training, and I'm not a college graduate, but I've been to multiple spent seminars, has informed how I try to understand my own clients, whether they have addiction issues. Maybe there's stuff in the medical records that makes them look bad on paper, or maybe they didn't go to the doctor like they should have. What is the reason they didn't go to the doctor? Really dig deep and figure out how to tell that story to the jury before the defense does. So you get to frame what the narrative is. Anyway, that's a long that's a long answer to your question and a follow-up comment.
So from your background in that world, the world of psychology, what ignited a passion for becoming a trial lawyer?
Well, I started out wanting to do immigration work, and that turned into, I volunteered at a immigration attorney's office, and that attorney actually did more criminal defense than anything else. His name was Vito Dela Cruz, and this is back in the mid-90s. And criminal defense was really interesting to me because there was so much drama involved. There was just it was high drama. There was, a crime committed. Sometimes it's a whodunit. Most of the time it's a, why done it, not or how done it, as opposed to who done it. But the way that Vito, my old boss, and then later he became my law partner here at Tamaki Law, the way that he looked at cases was unique. He was not attending Spence Ranch seminars that I was aware of, but that's the way he handled his cases. And I just really appreciated how effective he was in the courtroom, the respect that he garnered from judges and from co-counsel on conspiracy cases. And I was like, wow, he's really good at what he does. And he enjoyed trial, and he had like 100 trials under his belt. And so I just liked the idea of the courtroom battle, and how do you prevail when the odds are against you and your client? And I saw him do it so many times. It was inspiring. And then when I tried to work for him after I graduated from law school, because I clerked for him all of the summers during law school, and then after graduation, he ended up closing his office and moving to a different state. He connected me with Blaine Tamaki, where I'm at now. So that's where I interviewed after graduation, and that's where I am today. It's the only experience I've known in a law firm professionally as a licensed attorney. And here, I just had the same passion for courtroom advocacy. So I just soaked up as many seminars and trials and co-counsel experiences as I could to understand how to do this at the top of my game. And then later on, when I became successful in the sexual abuse arena, settling multi-plaintiff cases that made the news outside of Washington, that's when Vito read a story about what I was doing back in 2011, and ended up joining me here at Tamaki Law. And it was kind of a full circle experience, bringing back my old mentor now as a law partner and working with him, trying cases with him, and having that same, what I appreciated about Vito, he's retired now, but he and I had the same desire to become the best possible trial advocates for our clients. So we're constantly trying to learn, reading books, co-counseling, attending seminars, and felt that was the portal into getting great results for our clients. And that carries on through today. I mean, even though he's retired, my current law partners have the same drive that I do. And that's what makes, that's why when I get up in the morning, I still look forward to going to work. I still, there isn't, sometimes you dread it. Sometimes it's like, oh, really? I have to take a deposition with that opposing counsel or this client. It's like, oh, I wish this case would settle. Everyone has those experiences, but doing trial work is, I think, the most professionally and personally rewarding thing I can imagine doing. And you get paid to do it too. I mean, I would do it for free if I could, if I could survive and feed my family. It's not about the money for me. It's just about the, how hard we work to help our clients through these, navigate through these waters, and then to have the result that we get for them that is life-changing. I don't know where else you can get that kind of experience professionally.
I talked to our team about that because, we're somewhat of a part of that, at the end, but like that, how what you do has an impact for that person's life, after they've been involved in, what's usually a pretty significant and sometimes catastrophic injury. So that leads me to, I wanted to talk to you about some of your different areas of practice as well as strategies you utilize, because you've got some notable results. And in looking at some of the information from your practice, that you really have had a lot of success litigating car crash cases with recoveries that exceed $1 million. So I wanted to ask you about the strategies you employ to maximize the recovery in automobile accident cases, because that really jumped out at me.
Yeah, with car crash cases, and I think this applies for any type of case, really. I think it's all about the team. So the team includes not just you and your staff, you and your partners, but also the experts that you put together. So with a car crash case, I start off with who is our accident reconstructionist. We need to lock in the evidence, get the photos taken, get the video taken, purchase. We have a case right now, multiple death case here in Yakima County involving a specific type of vehicle that it was a truck, and I can't get into too many details about it because it's pending litigation, but we ended up purchasing this same make and model vehicle on eBay, and we're using that with our experts as an exemplar vehicle to take the same route that the defendant driver took. And it's that type of attention to detail that is not, I mean, these aren't my original ideas. So that's another thing I've noticed about trial work is, the trial lawyers get credit for these great results, and they get kudos and, hey, good job. You settled a case for, $2 million or $3 million or $10 million. But a good trial lawyer, in my opinion, is just a good manager. And so not just a good manager. They have to be a good manager in addition to other things. But being a manager or a coach, just like a football coach, you've got Pete Carroll for the Seahawks, and that's my frame of reference because I'm up here in the Pacific Northwest. But, what makes Pete Carroll so great at his job, or if you're on the East Coast, what's the Patriots coach name? Bill Belichick. Yeah. So regardless of where you are, the great coaches know who to hire and where to put them, and what is their highest and best use. How are they going to help this team win? And that's how I look at experts, is I try to put together like the dream team. And that's especially true in medical malpractice cases where you really have to think 3 and 4 moves ahead. Should I hire an expert who does 90 to 95% defense work? So they can't be attacked on bias, because here they're working for the plaintiff, but most of the time they work for the defense. That's how strong our case is. So how do you create this narrative through your own experts that shows you are going to win this case? And if the defense doesn't believe it, then in fact you will win this case because they're so strong in front of a jury. So if it doesn't result in a settlement, it's going to result in a big verdict. And so that's where I try to put my focus, is on the management of the case, managing the dream team, putting together the A team. And then also at the same time, we're spinning multiple plates, but you have to listen to the client, learn their story, use psychodrama if you need to get to that story, and make them feel heard. And so then you're empowered. And then also more these days than in any time in my career, I am using trial consultants. So I should be hiring them much earlier in the process, but I was supposed to try a car crash case with my law partner a couple months ago, and we were using a trial consultant that I wished I had brought on a year or two before. But in the months before the trial, this particular consultant, and I'm not going to say his name because I don't want other people to, I want him to be available for me. Maybe that's a selfish thing to do, but he's a very special, brilliant, intellectual giant of a trial consultant. And he's behind some of the biggest verdicts over the last couple of years in the country with a lot of different law firms. But you can find them. They're not hard to find. Just talk to people. Go on to listservs. What trial consultants are you using? Who are the folks that are helping law firms get great results in cases? And that's why I enjoy this practice so much. Is it doesn't have to be, Bryan Smith is the genius behind, this result, and I have to learn every aspect of the medicine in a medical malpractice case, which I do try to do. But, what I want to do is I want to find the best expert to go up against the defense experts. And I want to find, and sometimes, when you're trying a case, you realize that your client is going to be best served if you bring in another firm. And I do that too. I don't try to hold on to a case to have the glory when it settles, or when it goes to verdict and there's a good result. What I want to do is say, how do we service this case and this client so that we get the best possible result? And if that means bringing another firm that has more experience than I do on a particular type of case, then I do that. And another side benefit of doing that is just learning how other people work and how they think. Focus groups, that's another area that's kind of a crossover into trial consultants. But trial consultants will do they'll conduct focus groups, and they can do them via Zoom, they can do them via questionnaires, they can do them in person, in the venue of your choice. And that's immensely helpful. And that helps you understand aspects of your case and reveals issues in your case that you didn't even know were issues before. And it's that type of gestalt, which is, the dream team of experts, the trial consultants, the focus groups, the psychodrama to understand your client's story, and then having the guts to try the case if you need to. That's kind of the ingredients of great advocacy, in my opinion.
You've been involved in high-profile cases, including obtaining a $167 million recovery on behalf of victims of clergy sexual abuse. What are the unique challenges and responsibilities that come with representing survivors in these deeply sensitive and complex type cases?
Most of the multi-million dollar $100 million plus cases involving sexual abuse are cases where there's not enough money to go around. So they end up in bankruptcy or in some type of pre-bankruptcy or the threat of bankruptcy. A lot of the abuse happened decades ago when, some years there was no insurance coverage at all. The church has taken steps to protect their assets. They've moved money around. They've transferred title of certain properties to outside folks or other entities. It's extremely complicated, messy case. And the result is that there's just not enough money to go around for what they went through. And so it's a tough conversation to have when you have, for instance, I just resolved an out-of-state case this year, and it was a multi-plaintiff case involving hundreds of plaintiffs, and the case settled for, I think the global result was like $129 million. And any one of those cases out of the hundreds that filed claims is worth more than $129 million. So how is that justice? And that's the tough conversation that has to be had with each individual claimant. Same thing in the Boy Scout case that's still active right now. And that, if that settlement gets approved and is not sent back by the Court of Appeals, there's going to be a lot of tough conversations that attorneys are going to have with their clients about case value. But there is, I think that there's value in the claims process that will hopefully result in a feeling of closure and will make it worth going through the hardship that they're going through to file their claim. There is some measure of accountability that's achieved through those cases, but they're really tough from that standpoint because, at the end of the day, if you're handing a check to a client for a couple $100,000 or, whatever the result is that is not full justice, how do you talk about it in a way where the client can feel like, yes, the attorney did everything they could for me, and I'm glad that I came forward and told my story, that I made a difference somehow. So that's, I think, the biggest challenge with those types of cases is just trying to manage client expectations and also trying to find a way to talk about it so that, and this isn't, trying to put lipstick on a pig or, trying to frame it in a way that's dishonest with clients. It's just trying to really find the narrative that allows the client to find some peace, that it was worth coming forward and participating in the case. And also, it's very hard to get to trial in those cases because oftentimes the defendants will file for bankruptcy and it puts a stay on all litigation. So the folks that think that they're going to have some sort of catharsis through a trial process, they don't get to achieve that. But the flip side is they don't get forced to go to trial. There's a lot of people that do not want that option. They would prefer to have a more informal process of, having their claim evaluated by a claims adjudicator and, getting something that is, including an apology letter and some commitments to make changes so it doesn't happen again, and changes in policies and procedures within the church. And so that they feel like, okay, yeah, it's not enough money, but at least there's changes made because I came forward that are going to hopefully protect kids in the future.
Case in my career a number of years ago where I was assisting in a matter in New York which involved a foster parent situation that was abusing special needs children that were under her roof. And I just remember very vividly the idea of how do you value, because part of the question was how much does each person get, and how long were they exposed to that environment, and but yet all of them had either psychological issues or drug addiction issues, you know, just from being exposed to the situation overall. So all of that, I would just imagine, is even more amplified in some of these higher profile sexual abuse cases like you talked about. It's that area to me is one that is just difficult because of what's occurred. Not that any of these cases are easy, because having seen all sorts of catastrophic situations, all of them can be, you know, very, very tragic in their own right. So um, there was a settlement that I wanted to ask you about, because it was a medical malpractice case, and you had mentioned your what you do when you're representing someone in a med mal case, which is dive into the medicine side of it. And I know from having done defense work in the med mal area that those cases are time intensive and expensive to litigate. You had a $12 million settlement in what was I don't know if it still is, but the largest medical malpractice settlement in the history of Central or Eastern Washington. Can you talk about the impact of getting something like that kind of recovery in your client's life, and also the broader impact in terms of the pursuit of justice in healthcare?
Yeah, I can't talk specifically about that case because of the nature of the confidentiality agreement that the client signed, and but they're settling a case of that magnitude for a client is really rewarding to see happen, because there's a reason that the case settled for what it did, and it's because a lot was taken from the client. And so to see something come back to them that obviously is not going to make them whole, it's not going to turn back time and make so it didn't happen, but it does make up for a lot, financial security. And this from being on the settlement, the structure side of things, and helping folks with settlement decisions. It can be life-changing, and it's really rewarding to change lives in that way through the transfer of money. I mean, I almost look at it in a Robin Hood sort of way. It's not that we're robbing from the rich or stealing from the rich and giving it to the poor, but what we're doing is we're requiring these companies that have immense resources, like insurance companies and corporations, to be held accountable, which is really, really rare, especially today when the differential between the haves and the have-nots has never been more stark. And so, the billionaire class has become almost untouchable these days with with accountability. There is no accountability, or it's very hard to find situations where billionaires or individuals or multi-billion-dollar corporations are held accountable ultimately for wrongdoing. So when you are part of making that happen, and you see the benefits of your client actually being able to breathe and not have to worry about being homeless, it's very, very rewarding. And throughout the case, the most the case that we were just talking about, the multi-plaintiff case that settled for 129 million, a lot of those clients were, I shouldn't say a lot of them, many of them were homeless. I mean, they had addiction issues. They were on the verge of homelessness or homeless at various times throughout the case. And so to settle that case and to see how it changed their lives was just as rewarding as it was in that medical malpractice case involving a $12 million recovery. It's like you just feel you feel like you're doing something right. And you know you're on the right side of things. And not to disparage anybody who does defense work, because I know you did med mal defense work, and everybody deserves to have an advocate on their side. But when I achieve results like that for clients, I feel like I was right. I'm doing something right here. And I just love what I do for that reason, that I feel like I am morally and from an integrity standpoint doing right by my clients. And in terms of changes within the medical system, that's a really hard one to gauge, because they have this, this doing defense work, they've got this system that's very cloaked in secrecy, which is, their behind the scenes assessment of what went wrong. You'll never see, no matter how hard you try in litigation, you can't get your hands, at least in Washington state, you can't get your hands on it. Quality assurance, they call it in Washington, Quality Assurance Commission. And so you really don't know, what types of changes are being made to make sure it doesn't happen again. I've had wrong patient surgery cases that I've settled, and I had no idea afterwards what steps they were taking to make sure that they didn't operate on the wrong patient again. Sometimes you're just crossing your fingers going, gosh, I hope because they paid out all this money, they're going to make changes so it doesn't happen again. And then, maybe some attorneys are actually insisting on seeing the changes being made. And maybe that could be part of a non-monetary term of the settlement. In the sexual abuse arena, we almost always insist on non-monetary terms of the settlement, meaning we want to see policies and procedures in writing posted on your website so that we know this is at least the chance of this happening again is low. So you're taking active measures to make sure it doesn't happen again. So that's something that trial lawyers, it's a tool in our toolbox, non-monetary terms of settlement. Defense lawyers don't like it. They like to keep it limited to, all right, it's just, here's some money, sign the release and go away. But, if we're really in this for the right reasons, we should be thinking about cases that way. How to make, it's a public service that we're doing, how to make sure that folks are protected in the future, that our community is safer in the future.
I mentioned in your introduction about the Strauss Institute for Dispute Resolution, and you're actively mediating cases. How has that helped you in your own practice?
Slight correction on the bio. I did graduate from the Strauss Institute. I do mediate cases, but I have not started an active mediation practice yet. So I am not serving as a mediator yet. I've been reluctant to put up that shingle just because of my trial calendar, and I'm not sure I have the time yet to start mediating. I have the desire to do it. I don't know if I have the time. But mediation has always been, for me, I felt very comfortable in that setting, in mediation, because I feel like getting the perspective of a good, experienced mediator helps me better prepare for trial, even if the case doesn't settle. Like sitting down, seeing your client go through the process, which is like, they're under the microscope a little bit. They're being asked questions by the mediator. They are getting a little sneak peek at what the defenses are, how the defense is looking at their case through, filtered through the mediator. And it just helps me become a better advocate, and it helps prepare my client and set their expectations for trial. So I think I like mediation. There's a lot of attorneys that are rough and tumble types that are like, I do not mediate. If the local rules require me to mediate, I file a motion to get out of it, and they refuse to mediate. And that's fine. I mean, everybody has their own approach to litigation and advocacy, and I don't, I don't judge them for not going through the process. But for me, I really appreciate mediation because ultimately, if you can get the case settled, even if it's for a result that's less than the client was maybe hoping for, but they can live with, and that's kind of the ethos of the Strauss Institute, is that a good settlement is where both sides walk away angry, or whatever the definition is. I don't think that that's entirely accurate. I don't think you want your client to walk away angry with a settlement, but I think what you want is you want the client to feel like they took control over the outcome of the case. And I think that can be cathartic. It's like, okay, I made a decision, a very calculated, thoughtful decision over the course of an 8-hour day mediating the case, that I'm going to take control over the settlement value of my case, and I'm going to settle this case. And that type of decision making, I think, can make the client feel like, I don't know, just a sense of satisfaction that it was them. It wasn't like, all right, here you go, 12 strangers. Let me know, let me know what my life is worth. Let me know whatever has been taken from me, you be the judge of how much that is worth. And I think most people really don't like the idea of that, of having 12 strangers decide their fate in that way. So that's why I like mediation. That's why I look forward to eventually opening a mediation practice and helping people resolve their cases that way. Another problem that I'm seeing is that courtroom congestion and cases being backlogged for years and years is justice delayed, justice denied. So here in Yakima County, it's not unusual to see cases get continued 3 and 4 times. And it takes sometimes 3 to 4 to 5, sometimes 6 years to actually get in front of a jury. And in the meantime, what's going on in people's lives? Other things happen. They get in a second car crash. They fall down at work. The case becomes more complicated over time, and that just plays into the hands of the defense. So I like mediation from that standpoint too. It's like, let's figure out a way to get this case resolved so that you aren't at the mercy of a clogged civil justice system.
Yeah, and that was definitely my experience personally. And having been a part of this system, I knew what to expect. But the idea of being empowered, one, to talk directly to the other side. Mine was a little unique because I did the damages presentation in my own mediation, just because my lawyer said, hey, you could probably articulate this the best and make sure the adjuster understands. She probably doesn't want you to be on the stand to explain what the impact of this has been on your life. As a lawyer, that's probably not a good decision to put a lawyer on the stand to do that. But just being able to have that opportunity and go through that process, that certainly helped me on the closure side of things. And I've seen in my career and working with people that there definitely is something to that, and taking that power back to determine the outcome ultimately of all of this, because and that was what was very hard for me being in the ICU, for example, was feeling completely helpless and zero power when you're in that kind of a situation. So I think there's a lot of reasons why that empowerment is so powerful for mediation.
Yeah, that's a good point, about speaking about your own damages, the client speaking at the mediation. I think that can be extremely powerful with mediators when they take that message back to the defense. Like, this is a great witness. This is your chance. They're ready to settle, and you do not want to have this person testifying in front of a jury.
A few more questions before we wrap up. I know that you used to have your own podcast called Dream Path, and you, through that podcast, explored artist journeys of musicians, filmmakers, writers, and other creatives. And I'm curious about how your passion for the arts intersect with your legal career, and also whether through interviewing people that you discovered any parallels between artistic journeys and the challenges faced by trial lawyers.
Yeah, it's a good question. I think I started the podcast to, I think what I was looking for is a creative outlet for myself, because I was a little bit burned out with just trying cases, just work and family. And I wanted something that was for me, that was kind of satisfying my own curiosity, answering questions about how folks who chose a different path did it. So the folks that chose to go into the arts, they dove in head first. How did they do it? Did they go to film school? It's like, if they're a film director, did they go to film school? Did they shoot a movie on their phone? Or did they, do a short film and put it up on YouTube? How did they get into their first film festival? Or if they're a music artist, like Moby is an artist that I interviewed, and how does Moby look back on his career in terms of how he fits into music history, what his intention was when he first started, why he's still doing it. All of those were very personally, those were my personal questions that I had. So it was kind of a selfish endeavor in a way. I wasn't creating the podcast and be like, oh, this is what I think other people may be interested in. Of course, I would love for them to be interested in this, because then I'll have more listeners. But it was really just a selfish endeavor for me to learn how to make the leap myself, because I was thinking, well, what if I want to be a creative in some way, beyond just picking up my guitar after work and, playing a tune, or going to my friend's house and playing guitar with them, or writing a poem or something like that. I wanted to know, how do you do this, the craft of music or acting or filmmaking? And what I found was that it became pretty obvious after the first few interviews, but it really got hammered in over the course of 3 years, that the people that were really successful at what they did, there was no plan B. So they said, you know what, I'm going to be a musician. And they made that commitment, and they did it no matter what. Even if they were poor, they were on the verge of not being able to pay the rent or put food on the table. They found a way, they hustled, and they made it happen. So it's that type of passion and dedication that allowed them to put in the 10,000 hours. If we're talking about, the Malcolm Gladwell 10,000 hours of how to become extremely proficient in anything that you do, that's what they did. And then I started to see, well, it's kind of the same with trial work. If you look at really great trial lawyers, I mean, that's all they're doing. They're trying cases, they're deep in it, and they're passionate about it. My interviews with, I think my interviews with clients and the interviews that I did of witnesses and depositions and the interviews that I did in podcasts, there was a lot of parallels there because I was the same person. No matter what the context, I was the same person. I had a different objective in each of those contexts. But when I take a deposition, I don't turn into somebody else. I'm very much like this with you. I'm naturally curious. I want to know. I want to step into their shoes. I want to role reverse with them and find out what the driver was thinking and doing and, what they went through, or an expert witness. I want to know, what their perspective is. And I want to approach it not from an arrogant, indignant standpoint. How could you take this position that hurts my client's case? I really want to know. And I think if you can understand another person's story, whether if that person is even an antagonist in your case, the better you understand their story, the better advocate you're going to be in the case for your client. The way I did that is through interviews. And so I interviewed folks in depositions. I interviewed people in podcast interviews and my clients. And so that was kind of a self-discovery situation where I was like, you know what? It's all the same thing. It's just being a human being, being naturally curious. And the second that I stopped being naturally curious with my podcast, where I was kind of like, okay, I'm asking the same questions over and over again. I think I know the answers. I don't think I'm revealing a lot that's new, so I'm not really delivering content that's unique and helpful and something that they couldn't get in previous interviews. So if my natural curiosity starts to wane, I think it's time to go. It's time to hang up the headphones. And that's what I did after 3 years. And it was a hard thing to do, but it was helpful professionally to go through interviews and podcasts in the podcast format, because I did discover that there are so many parallels when it comes to trying to discover someone's story and revealing that story through questions. And I think it helps you in the courtroom too. I think there's a reason that podcasts are so popular these days, that people that know how to ask good questions they're connecting with folks, and they are sort of asking the same questions that the audience is naturally wondering about. So you've got people that have, 100 million subscribers on YouTube that are, podcast stars. They're making hundreds of millions of dollars per year or tens of millions of dollars per year. There's a reason that podcasts are so popular, is that these folks that are really good, like Howard Stern is probably one of the best, right? Or at least, even if you don't like him, you have to at least admit that he's really successful. There's a reason that he's successful. And that's, maybe that's something trial lawyers can, learn from, is if you're going to be in a courtroom trying a case and you're asking questions of a witness, do you want to be the guy or gal who is tearing apart the witness, like viciously attacking the witness? Or do you want this person to be the likable podcast host who is letting the witness, if they're an opponent, if they're an antagonist, ask the questions in a way where the witness is going to sink the case themselves? So you let them do it. You're not the bad guy or the bad gal, so to speak. You're the person who is revealing the truth. You're the person who is revealing the story through your questions, not in a manipulative way, not in a performative way, not as shtick, but just you are the person who really wants to know what the truth of the case is. And that's my takeaway from 3 years of doing podcast interviews. Is like, I learned how to be a better courtroom advocate. I learned how to be a better advocate for my client, doing an initial intake, trying to find out what happened to them. I learned how to be a better witness interviewer. And also, it really helped me creatively too. I'm still, like, to this day, I'm taking voice lessons. I'm taking guitar lessons. Tonight I'm going over to my friend's house to play guitar for our weekly Wednesday night guitar session. And I think that's another important part of being a human being, is not overlooking our needs. Whatever, I'm not saying everyone needs to have a creative outlet, but they need something other than, their 8 to 5 job to be fulfilled.
Yeah, 100%. Really some fascinating little tidbits in there. Thank you. So maybe I asked a decent question there. I don't know, Couple of questions before I let you go. This next one I always ask. It's somewhat self-serving. What are the most difficult related issues that you face when you're settling cases today? Is it dealing with liens? Is it dealing with Medicare related issues? Is it government benefit preservation, like when someone's on Medicaid or SSI, or something altogether different? I'm curious about what you're seeing today as big issues when you settle a case.
All of the above. Everything that you've just listed there is, those are things that I talk to my law partners about daily. Dealing with really difficult lien issues, dealing with, and specifically on lien issues, ERISA liens. So, the health insurers that are not even health insurance companies, they're just self-insured corporations like Costco that uses Aetna to administer their claims. And you'll have a client who has back surgery and, permanent problems. They've got neuropathy in their leg, their feet, and they're never going to be the same. And Costco and Aetna will say, I don't care. I want it all. I want every single dime of that person's settlement. And it's really sad. It's a sad commentary on America that we've allowed lawmakers to have corporations just run amok like this, and over the rights of individuals. And so that's why I'm glad that companies like Synergy are around, as a resource for attorneys who are representing clients that would not get anything, or maybe would get a lot less unless they had the expertise of a settlement professional to help them negotiate a lien, or help educate, plaintiff lawyers on how to negotiate the lien themselves. And then you've got, public benefits issues. You can give, $50,000 to someone who was injured in a car crash case, but if it means that they're going to lose their medical coverage or they're going to lose their disability payments, it could be actually worse than if they had not settled the case at all and they never even had a case. So, dealing with public benefits preservation is another, important part of our practice. It's not a glamorous part of the practice. It's usually on the back end of the case where we're first talking about benefits preservation, but it's key, because if they lose benefits, their quality of life is going to go down dramatically, and there's a lot at stake there. I think it's one of the probably the least sexy part of a personal injury case is dealing with the liens and the public benefits and all of that. But it is probably the most important part of the case ultimately, because sometimes the easiest part of the case is the settlement itself. They'll come in with sometimes a client will come to me already settled the case. Like the insurance company has offered me their full policy limit, but I know that if I take it, I'm not going to get a dime of it because my insurance company is going to take it all. And so I know all of my work has to be on, the back end of the case, trying to figure out how to maximize the net in their pocket. And that's where synergy comes in.
So, last question, open ended. You can talk about whatever you want. What's your view as a trial lawyer?
What's my view as a trial lawyer?
Yeah,
Just generally speaking.
whatever you want to talk about that maybe we haven't talked about yet, or some philosophy you want to impart. Whatever you'd like.
I would say, you know, life is short, and I forget who said this, but live every day. I think it was Mark Twain. Live every day as if it's your last, because one day you'll be right. And that in the personal injury business, we see tragedies every single day that shock the conscience, and somebody can think that they're just walking across the street to go get a cup of coffee, and they step off the curb and they're gone. Their family is left searching for answers, and they're struggling to make ends meet. And it really makes you think about mortality and how much time we have on this earth. It's not a lot of time. So my personal philosophy, and this kind of goes back to the issue of creative outlets and kind of doing what you want to do now, is live your life now. Don't wait to live your life. Like, don't have a timeline of, well, in 10 years, that's when I'm going to schedule that trip that I've always wanted to take. Or in 5 years, I'm going to, do X, Y, Z. Do it now. There's just no guarantee. And a lot of the folks that were the hardest working people I ever knew growing up were some of my friends' parents who were doctors. And I grew up, lower middle class, and my family declared bankruptcy multiple times, and we struggled financially. But I had some friends who were pretty well off, and some of those friends, their parents were doctors, and they worked so hard. And one of those friends, his dad retired a few years ago. He took his first trip to Europe after he retired, and within a couple of months he was diagnosed with cancer, and he quickly died after that. I think within 6 months he was dead of the diagnosis. And that really made me think about this concept of living your life now. Like, don't wait to take that trip. And maybe it's just because of my profession and how people's lives are snuffed out too soon, and it's so awful, and I never get numb to it. I never get desensitized to it. It always affects me, especially when folks lose a child. But young adults getting killed, or dying from strange illnesses, it happens. And so that's a long way of saying, Jason, that that's a philosophy that I try to live every single day, is to live my life now.
I'm right there with you. Although it took getting hit by a car while I was cycling, which was my personal injury case, to really hit that more home for me personally. And from that moment on, I realized that I needed to prioritize things a little bit differently. Unfortunately, sometimes it takes something like that. But you're right, seeing these things over a career, hopefully most people realize that. But sometimes people are so absorbed with their work that they miss life going on around, and there are a lot of important things, family, and outside interests that help make you a well-rounded person, not just an expert in your field. So
Yeah.
great advice.
And I would also say, take care of yourself physically. Especially for trial lawyers, it's easy to make excuses like I'm too busy. I'm in trial. I get it. When you're in trial, there's almost no time to work out or whatever. But self-care is so important. And that means eating right, exercising, watching your blood sugar, watching your cholesterol. There's a great book that I'm reading right now called Outlive by Peter Attia, Attia.
Yeah. He's great. His podcast is great too. I don't know if you've listened to that.
His podcast is fantastic. I've heard some marathon interviews with Peter Attia. One of them, a couple of them have been on the Tim Ferriss podcast, where he succinctly summarizes a 17-hour audio book in just a couple of hours. But it's a fantastic book. There's a lot of books like that, but I think that's probably the best. And I think Huberman has one that's coming out soon too. But yeah, just pay attention to your health. And it's not being selfish when you do that. When you hop on an exercise bike or you go for a run or you lift weights, I think people feel guilty that, especially when they have a family, they feel guilty like, oh, I'm doing this for me. I should be focusing on my cases or my kids. But you can't focus on your cases and your kids if you're sick or you're dead.
Bryan, so if any of our listeners are interested in working with you on a case, co-counsel, or need to refer a case to somebody in your jurisdiction, or I know you do work in other jurisdictions as well, what's the best way to get in touch with you?
They can email me at bsmith@tamakilaw.com. That's TAMAKILAW.com. I'm at the Tamaki Law Firm here in Washington State. And you can, call me anytime, email me, and, even if you just want to run ideas on, experts or anything like that, I've got a pretty big data bank of experts that I work with throughout the country and a lot of co-counsel ideas on different types of cases throughout the country. And I've had the good fortune to meet a lot of brilliant, wonderful, generous trial lawyers throughout the country that have been great to work with, and I've learned a lot from them. So even if it's just to connect and say hello, reach out, and maybe we can work together one day.
We'll include your contact information in the show notes for today so people can find you. And thanks for tuning in to this episode of Trial Law Review, and we'll see everyone in the next episode.
Thanks a lot, Jason.
Thank you for tuning in to Trial Lawyer View. We hope you enjoyed today's discussion and encourage you to tune in to our next episode for more helpful insights about your practice. This podcast is brought to you by Synergy Settlement Services. Visit synergysettlements.com to learn more about how we allow trial lawyers to focus on what they do best.